On Tuesday the 27th of April, the Morrison government announced a ban on direct flights from India to Australia.
In addition to the measures I announced after the last National Cabinet meeting to pause direct passenger flights between India and Australia until the 15th of May.
Days later, the Health Minister, Greg Hunt, released a late-night statement highlighting strict penalties such as imprisonment and fines if people didn't comply.
This is not something that was accentuated by Greg or Hunt or me or anyone else. It was picked up on in the media, and they've highlighted that.
The pause that we put in place for travellers coming back from India is working. As planned, we will be able to return to having those repatriation flights from India from the 15th of May.
On Friday, a Senate committee heard first-hand accounts from Australians stranded in India.
We have been in touch with many parents who have not seen their children for a year or more.
Yeah.
And for my child, we haven't seen her for close to 17 months.
How come it's over 1 year after first wave we had at least 8 months to bring everybody around the world back here, and it didn't happen?
The federal court has partly rejected a travel ban challenge made by Gary Newman. He's been stuck in India since March 2020. Michael Bradley is one of the lawyers representing Mr Newman. So, Michael Bradley, what does this ruling mean?
Well, it means that as a part of the challenge that we brought against the Minister's declaration has been dismissed by the federal court this afternoon, so that part of the case is over. It still leaves the constitutional questions which were not brought forward for urgent determination, so they're still in the wind. But for the moment, the declaration remains in effect.
So the part that was struck down, that was the part that was relating to the use of the Biosecurity Act, is that right?
Yeah, there were a number of limbs to the arguments that we brought forward today and the court dealt with. We were arguing that the Minister misapplied his discretion under the Biosecurity Act and didn't take into account all of the things that he should have. And we also argued that the Biosecurity Act doesn't apply to override a common law right that attaches to citizenship to return home. Now, it was accepted by the Commonwealth and the judge that right exists, so that's quite an important principle, that we all, as citizens, do have a fundamental right to return home. However, the judge found that the Biosecurity Act actually overrides that right, and in fact, to the extent that the Minister can pretty much do whatever he wants, which was against what we argued.
I think some Australians would have been surprised to learn that there'd be any circumstances under which, if you were overseas, you could be barred from returning home to Australia. What are the other grounds that you've got to argue?
Well, so what's sort of left over are two constitutional arguments. We say that apart from that sort of common law right that I mentioned, that the Constitution itself actually contains an implied right for citizens to return home as a sort of an essential attribute of citizenship. If that's right, then that would override anything the Biosecurity Act said about it. The other is that we don't think that the Constitution gives the Commonwealth the power to make laws that would prevent a citizen from returning home. It's not something the Constitution mentions.
We'll have to see what happens. Michael Bradley, thank you.
My pleasure.
Hi, I'm Leigh Sales. Thanks for watching this story. If you'd like to watch more of 7:30's stories, they are on the left of your screen. And tap on the button below to subscribe and get the latest from ABC News.